Okay, good evening everyone. Thank you for joining us for our second online seminar of the day. And this evening we are lucky enough to have the skills and wisdom of Henry Hathaway, partner in the construction team, who'll be talking to us about effective delay analysis, the tools and techniques. Just a brief change from our usual setup. We've now upgraded our platform, and therefore you can submit questions. If you look on your bottom toolbar, you'll see a tool that says Q&A, and if you bring that up you can type in your questions and Henry will do his best to answer as many of those as possible at the end of the session. Okay, without further ado, Henry, over to you.
Good evening everybody, and thanks very much for joining on what is a very, very nice evening. The current position in terms of the events surrounding construction contracts and the delays that are currently being experienced, we've already previously discussed about the frustration, force majeure, and the impacts of COVID and coronavirus on the mechanisms of construction contracts. So inherently, a lot of those points and what we would describe as being liability certainly become to the forefront, and discussing then if we do find that there is an entitlement to further time, we now have to establish what is the time. Over the course of the last number of weeks, there's been various different positions put out by the government. I think there's no less than 4 different parts, especially when you consider the guidance in how it's presented by the government in advisory form and whatnot, the effects of even the Coronavirus Act 2020, various regulations that have been updated, and how these all impact, and certainly what effect the guidance itself has. So we're entering into an area now that even if we do manage, in some instances, not all, but if we do manage to look towards, say, for example, force majeure as being a point that a contractor can rely upon or a party can rely upon, and that is in a very definitive set of circumstances that has to be established, there is always the point of causation. And we are now actually even more so talking about when does time, how is it measured in a quantum element to prove the amount of time, the causation, and how that is actually established. And these are going to become very critical questions. Ultimately, what appears to be happening is that a number of parties haven't quite grasped at this point in time what will be the outcomes in terms of time, and especially in monetary terms. So we believe that these are going to be large disputes oncoming if they're not grappled with at this point in time. So for example, how do we prove the elements? So in one respect, if a party were to say, for example, that during a period of lockdown, that actually was a root cause of a delay, how therefore does a party now actually take towards the next steps of saying, well, there may not be lockdown, we're quite fine to approach the works, but in this instance, we have social distancing that has impacted on disruption. So assuming that there is a point on liability of that it is a right to be claimed, and of course that takes its own unique instances, what of course would the elements of proof be required towards that? So we're expecting quite a lot in the near future, certainly surrounding how the events of the post-lockdown, what the impacts actually are. So if we now take the points to say the need to prove delay, so if we're looking to say to defend a claim against, say for example, liquidate damages, so ultimately the threat being that if a contractor actually does not complete the works by the completion date, again, usually most provisions will be that there is liquidate damages to be applied or levied. Secondly, of course, is to find a claim against employing party and additional monies associated with that delay. So, of course, if once we have established that there is a time delay, there may be a consequence of what the sums could be, if those are available. Remembering that in this environment, if a party under JCT, for example, were successful to suggest that a relevant event is, in particular, say for force majeure, we do know that force majeure is not a relevant matter. So those two are very distinct and separate points. And again, to the third point, to find a claim against the employed party for any loss, expense, or damages. So the assessment of the delay, and regardless of the different items of the pandemic at this moment in time, it will be the case that the straightforward rules of the contract will persist on that, under JCT, the delay to the completion date, or if there's been a previously adjusted completion date, what that adjusted completion date would be. So all of the rules under the contract still actually persist, and they still do continue. And there is no softening of that. And ultimately, the parties will have to maintain that if there is a risk or a liability element, it will be the case that a party will ultimately the rights and obligations under a contract. Under NEC, of course, we've got clause 63.3. Delay to completion date is assessed as the length of time that due to the compensation event, planned completion is later than the planned completion date shown on the accepted program. So in terms of what is a program for, traditionally, and most, the straight answer that most parties will always maintain, and we still say that a lot of the times that when there are disputes in construction contracts, that they have all been generated, or certainly a vast majority at the time of formation of the contract. That's when the actual issues, so during the tendering process, when we actually look towards what a program actually develops, how the JCT actually calls for that, for example, compared to the NEC or any other forms. But most people will actually suggest it's primarily a management tool for programming the works, for monitoring progress. But inherently, as well, a well-developed program is going to be the basis of making or defending a claim. It will show a properly constructed, maintained program will actually provide the certain element with supporting evidence of causation, and certainly support that. All too often in these respects, we still see that the level of detail or the functionality of programming simply does not support, and it's not backed up by the necessary evidence to support each of the different claims on those. The cross-linking, of course, between evidence, correspondence, versions of events compared to what the impacts of the program are, especially when we talk about dependencies or linked logic as well, simply does not always match. Now, in terms of actually seeing with those 4 points, clearly this is not best served as a retrospective. It is very little use to a party to retrospectively try and suggest what they wanted to prove as being the case at the time of contract. It's much more, certainly within disputes, the principle of what the courts will apply is, what did the parties intend at the time of formation of a contract? Certainly with the benefit of hindsight is not going to assist. Of that instance, the type of resource, the type of sequencing, the type of planning, that the more developed the program, or certainly how it stands, is how that actually assists. This is the time of the formation of contract. And it certainly assists later on when we're going to impact on that particular set of events. And is a contract, is it a program? If it is, what's the implication? Does the contract make express reference to the program? Does the contract contradict the program? What are these type of events that actually occur, and how it actually presents? So there's often been a case where, say, JCT, it was always regarded that it wasn't a contract document, it was a provision of the contract to provide a program. And traditionally it was within 2 copies, etc. So there is a very good reason why that was, because if it was a contract document rather than a provision of the contract to provide one, of course, in 2016, now we actually have in the particulars where there is choices there. The difficulty would be that every time that the contract actually, that the program actually changed, would in effect could amount to a variation to the contract rather than under the contract. So that is the reason why it actually took this form as being a provision to provide a contract rather than being a form of a contract document itself. But then, of course, we have JCT wasn't particularly more developed than that. It's only in the 2016 version, of course, that it actually starts talking about critical paths, whether they're appended or not. But other than that, JCT really looked towards the program as being that the contractor has a commencement date and has a completion date. And between those, it's up to the contractor to organize, if you like, how it and free to arrange those works and how, in what sequence order, in order to actually produce the end result. When we compare, say, to NEC, of course, has somewhat more developed, perhaps not to the extent that we often draft in Z clauses to provide further reasoning or further points, but certainly it does set out those further steps that the contract under the NEC actually does provide. So if it isn't a contract program, well, what should you show in the program? And typically, we're talking about the earliest start dates, latest finish dates, the provisional sums, and the access. And when we actually describe why these become very important, but essentially as a minimum standard, this is one of the base points which will or may have to be impacted later on. We'll talk later on about sort of as planned versus as built as techniques. But critically, when we look at, say, the elements, we find them very bare, usually, of these programs. They are, for some reasoning, and usually, typically, because I think contractors feel as though they're releasing their hand in some respect. But that's a double-edged sword, because they may have to rely upon these instances later on. But we find that provisional sums, as one example, are never included as they ought to be. Certainly, access dates to certain areas. This becomes incredibly important, of course, when you consider NEC. But realistically, if there are access dates to certain areas of the works, it should be marked as well. As a minimum, I would have always expected that all of the activities that you would see on an activity schedule, or certainly a bill of quantities or a CSA, each of those elements would be, I would expect as a minimum, to represent an activity, if you like, on each of the elements. And of course, provisional sums, because certainly if we put a notional sum or a notional time, we'll want to immobilize that later on during the course of the works and then impact what the actual, under the variation or rules or valuation, and certainly what the time requirements. That is one of the key points that seems to, again, get missed. Most parties, when they look at provisional sums, they certainly look at the provisional sums in relation to amounts or sums rather than the actual time and integrating the two. And that typically is a form of habits and generally the type of trends and patterns we see within construction works is the two separate disciplines between programming and QSing not merging, or no alignment between those. And suddenly we think that both of them, even though they are separate activities, certainly need that little bit more alignment. And then, of course, the question, when should you revise a program? Again, this will come to in a very typical or instance where it would be ideal, certainly whenever an activity has changed or completed on a given element. If an activity has been completed, you certainly would want and enjoy a back analysis, if you like, of how that performed in terms of resource and or timelines. But certainly the trigger point I would certainly put forward, that the key point to revise a program generally is when there's a change. A change can amount, is there a variation or a delay, or there's some significant departure from what was intended. Now, if we were to do that, that ultimately means that we ought to be revising quite on a regular basis to reflect the changes that do occur in a realistic nature. And that is certainly something that would be promoted. Now, we do certainly, having taken a lot of our clients through this process, we generally would think that this is a process which might take about between an hour and 2 hours a week in some instances, but it depends on the complexity, it depends on the amount of activities and certainly the size of any given project. But these are, and remembering as well that one of the key areas of disputes is because of an inability in relation to time to demonstrate when one's position. If those type of efforts of time going in at this stage do appear rather large in terms of the number of hours per week and with the quite point, one has to then consider what are the effects if you go into a dispute and having to undertake these works retrospectively. In terms of the NEC, clause 11.2, sub 1, the accepted program is the program identified in the contract data or the latest program accepted by the project manager. The latest program accepted by the project manager supersedes previous accepted programs. And anybody who is quite used to NEC will understand that, of course, the difference, and one of the chief differences between this and, say, the JCT, is that at the formation of contract, or that program at the very start, if you like, at common intention time of parties at the time of contract, is actually what we would term the baseline, where in fact the NEC, the baseline actually progresses. NEC has this very forward thinking that the program and the cost element always get updated as the program and as the works progress. So the theory behind it is that all previous events have been dealt with in the updated program, becomes a new baseline, and we develop as it goes through. The practice is generally, as we usually find, is quite something different. We often come across the common problem, which is a common complaint before NEC 4 came into play, which was to say that, well, it's simply impossible to have a project manager accept the program. And that would cause all numerous amount of issues as to what, therefore, would the actual correct baseline program be to dispute upon or to put forward a case. Now, of course, NEC 4 has corrected that element about deemed accepted, and it's not simply good enough for a project manager now to simply ignore a program submitted for acceptance. And there are only a number of given reasons why a submitted program cannot be accepted. So the accepted program is a developing document. It's updated to reflect current progress and revisions to the proposed sequence. So if we now look towards the techniques, and if we are looking towards, say, the type of questions when we're looking forward, say, well, what are they that need answering? The first question that one must ask when we're actually going to look at a delay is, what was supposed to happen? What actually did happen? What are the variances? And how did it affect the project schedule? So this actually becomes some of the critical questions, and the important habits and the important skill sets is actually to understand how to answer these questions invariably. And they might sound straightforward, but what was supposed to happen and how do we establish what was supposed to happen? And if we take the very baseline, we set out on a baseline and we establish what the common intention of the parties of the contract was. This then becomes more and more critically important as to why we must pay as much attention to the baseline program as possible. It sets out a number of different points. It sets out our intentions, and if those intentions do change by different external factors, which would constitute a relevant event, then we want to be able to establish that very clinically and very neatly from the outset. So for us to prove what was supposed to happen, we must actually set out what was supposed to happen, what the common intention was. What actually did happen, the reasonings why of course, we want to measure the change. We want to measure the change between what was the common intention and the baseline and what in fact did actually happen. So how do we prove what actually happened, of course, then becomes a matter of evidence. We often find that this level of evidence, evidence you can imagine is a spectrum in terms of quality. And of course, if it's a very poor quality, it's more than likely not that you're going to find it more difficult to prove your position and prove what you allege. And of course, we want to measure those differences. And then we want to see how did it affect. We want to see, because how did it affect the project schedule? We want to analyze, because what we want to analyze is, does every delay contribute to an overall delay to the completion date? Or are they delays in effect that are outside the completion date, or so outside the critical path, but indeed they may give some rise to compensation, but not necessarily affect the delay date. So we really want to get that picture to understand, is it excusable or is it something that can be compensated? These terms become very important. And again, this is exemplified by saying there's three types. The contractor assumes a risk of cost and time consequences. Now, how does that happen? Usually, in most forms of standard form contracts, especially the larger projects, there will be amendments. The allocation of risk, of cost and time, and they are very regularly dealt with. They're dealt with under standard forms, and they can be fully amended. Remember, parties are free to agree whatever terms they like once they, of course, meet certain criteria, as has been lawful, of course. But other than that, the allocation of risks. So when in the position of fairness or what different parties' certain viewpoints are, the courts or certainly disputes, they're not determined by simply putting forward a position to try and make a bad bargain a good one. The effect is given to the terms. So if there is, for example, ground risk, which is a very common amendment, or the risk of surveys that has been undertaken prior to the appointment of the contractor, if they rest with the contractor and we find that there is difficulties within the ground conditions, groundwater is always a famous one, ultimately, if those risks have been assigned, any time or cost delays that result as part of that, the contractor could find themselves very much bearing all of those risks, and in fact finding themselves in a much more difficult position. But the second point, the contractor is entitled to its cost and time extension or events for which no party has control or bears risks. And they can often arise as well. And there can be instances, as we mentioned earlier on, where you have, say, for example, a force majeure, as is very common a term now, which is to suggest that it might be a force majeure would constitute a relevant event, but it certainly wouldn't constitute a relevant matter. So you get time in that instance, well, if you could prove it, but you certainly wouldn't get cost. The contractor will set out the risks and obligations. The contractor will set out the risks and obligations of the parties, and ultimately we have that baseline. This is the importance, again, to the point of why we suggest that the time of contract becomes critical. What was the party's intentions, and invariably what changed, and how much, and to what extent? So, how do we ascertain the extent? And ultimately, there's 6 methods. One of the key points that should really come to the forefront is, why are there 6 methods? Isn't it right, or isn't it as simple that for all of the technology that we have, shouldn't there be just one method? If there is only one method, it would be more clinical, more approachable, and it could be applied to everything, and that would be the case, rather than 6. So why have 6? Ultimately, it comes down to the quality of evidence, the quality of information, and the size complexity of the project against the type of information available. If we have very, very poor records, if we have very poor information that we're inputting in, we will always struggle. And a lot of these trying to do it retrospectively. It's not unusual to come across projects that have been for an extent of over 2 years or so, and to try and realize the type of evidence and the gaps sometimes to do these type of techniques retrospectively is an inordinate task. And again, the point of being kept up to date for a smaller amount of time, and the cost involved in disputes for rendering and to establish these amounts. Well planned out and kept up to date throughout actually allows the parties at the time to discuss the matters rather than resolving into disputes. So dispute avoidance by keeping up to date with these points. But the reason why we have 6 is because of the quality of evidence. If we don't have very, very good records, or we can't substantiate those allegations very well, especially on paper evidence, then we will struggle. We will, but the better our quality and understanding what type of information we actually need, what type of information would actually provide the best chances of getting our version of events to be the most convincing. If we look at it as planned versus as built, so what we actually suggesting at this, all delaying events are depicted on the schedule. The difference between the time as planned versus the as built completion date is the time received. Critical path is determined once in the as planned and then in the as built. So ultimately, we have quite a number, and having dealt numerous times with this method because of the different levels of information available, what we actually find in considerably far too many occasions is that the as planned produced at the very start is frankly wanting. And you might have an activity that may last for some year or 2 years, and you are now looking at an as planned program for some 20 or so activities, which doesn't really reflect all of the elements even, or doesn't reflect the interim applications, or it's very difficult to ascertain. But the real difficulty is that it does not scrutinize the delay types and could be subject to easy manipulation. It ignores the dynamic nature of critical path and the changes in logic, changes in sequence, changes in dependencies. There's no attempt to determine individual impact of each delay on completion. But ultimately as well, we have to ask the question, what if the as planned is completely wrong? What if it has completely missed the point and it hasn't had that necessary inquiry or application at the very outset? Invariably, we're going to struggle. But the pro on the covers is to say it's easy and inexpensive. Now, that's a matter of application. It's whether or not a resulting dispute would counter that pro in itself. And when we looked at the impacted versus as planned, this measures the impact of delays on the contractor's as planned critical path network. Various delays are formulated as activities and added to the as planned network in a chronological order, showing the effect of each delay. Dates between the networks before and after the impacts. So it's simple and inexpensive. It's popular for retrospective analysis, but it uses a fixed as planned network. So I'm back to the point of a fixed as planned network, which invariably could be wrong. And it's a very, in disputes or in these circumstances, it is reasonable to place assumptions, but it is a very, could be quite a large leap in some instances if we are dealing with something that inherently could be wrong. But the original baseline may be incorrect or not realistic, may fail to consider all delaying events and disputes as to the adequacy of the as planned, again, as I've mentioned. But it is simple and expensive, and it is one of the most easiest to run. Now we have the as planned but for. It entails injecting the as-planned schedules with all delays of a particular party to form an adjusted network. Completion date of the adjusted as-planned schedule compared with the actual completion date gives the amount of delay for which the other party is responsible. Technique is applied to the network first for the contractor's point of view and then to the owner's point of view. To perform quickly, so there's no need to consider the actual progress of the works, but it does not take into account any changes in the critical path during the project. It assumes the planned construction sequence remains valid, of course, as well. The differing viewpoints and outputs by both contractor and the employer. But what you can actually see in this instance is that there is at least those elements, if you like, of more sophistication being entered into, although slightly. And the ability, of course, to look into what type of level of information, and of course this now is obviously raising the point, how good or how consistent is our level of evidence. And if we look at the collapse as built, it's a form as built for analysis, but does not use the as planned as a baseline, but uses an as built schedule. So of course, sophistication is now getting that little bit more likely that we're actually using an as built schedule. It involves removing delays of each party from the as built, so the resulting schedule will give the completion date of the project, but for the delays of the other party. So in fact, we're using the as built, which of course now is taking out that ambiguity or a version of events that simply could be wrong, which if the as planned was not correct. Its perceived advantage of this technique is that it's based on actual event, and it gives it a little bit more credibility. Credibility is the word as well, because certainly where delay analysis has come before the courts, and certainly where retrospective versus prospective analysis techniques have been used, or as planned when it's facing a judge as to the contemporaneous documents or what actually happened. It has been the case that judges have been that little bit skeptical and not very well pleased in respect of pure format rather than actually what the contemporaneous events are. So certainly the more to actually involve in the correct course of events will certainly become even more rather than procedural. So the cons is once collapsed, forced to insert after the event logic links. Delays being removed could result in unrealistic network, especially when delays are integral. Ignore circumstances and dynamic nature of the critical path. Input information is highly subjective, one version of over another. And again, of course, like when you're trying to bring in after the event, you're now imposing on those points logic links and dependencies, which may or may not be subject of debate. And of course, if we're now talking about linked logic and we're talking about dependencies, of course, that's going to change possibly what the critical path was. So is this a case that it's now easier for a party to give their version of events and to make the events fit the facts rather than the facts fit the event, which is of course critical. So there can be that debate. What we're trying to do at this stage, if there is a dispute, we're trying to narrow issues. We're not trying to broaden them. So when we talk now we're getting to the point of window analysis, and just invariably in the short while, the time impact. The window analysis involves interim assessment of delay on updated networks at a specific period of the project. It's very similar to a snapshot. Total project duration is divided into a number of time periods, usually based on mature circumstances. Network within each window is updated to reflect actual durations and sequence at time of delay, whilst remaining as planned is maintained. Difference in new completion date against the as planned provides the delay point. So we do have the as built position, but what we're actually doing now, it's the schedule is updated to reflect the actual duration. And effectively, we're now looking at a real-time event. we're breaking these up into significant, in specific areas. We do maintain after the timeline that we are, the as planned position, but now we're dealing on what the quality. So the key debates that always generally surrounds these, again, is the timeline, the effect of what the timeline was per activity. So we want to be really looking towards what can we actually do to prove the elements. And what we often find is this is information that the construction industry actually maintains. It maintains it very, very well. It's just the alignment between updating the project programs against what type of information they actually have. So for example, usually in my days as in engineering, there would have been always pre-pour check sheets, or certainly handover, or all of those different points, which really are good evidence in terms of how that actually builds up into those appendices to prove the actual times of when something happened. So pour dates, or all of those elements. We often find that the type of information that's being actually recorded in the construction industry is exceptionally good in some instances. And I think that it has to be fair to say those points. It's the alignment, and it's how they're actually brought together and integrated to reflect the course of events. To do these points retrospectively is quite a considerable resource for any company to actually put forward. One of the pros, of course, is it divides a complicated network into a coherent structure. It takes into account the dynamic nature of the critical path, effective approach to analyzing delays. More snapshots, the better. Cons, time-consuming and costly. I would suggest that time-consuming and costly if one is trying to do it at the very end of a project, or if they wait till a dispute. I think that's generally, I think that when behaviors and habits and when there's alignment, I think that the key thing, if we're to look at between how to record timelines, when that is aligned very well with the actual activities on a given project, and of course when the cost management or QSing, of course with variations, especially because every QS is going to want to claim and have their activities and detail those out. So I see absolutely no reason why that shouldn't be recorded as a time element. In fact, I find it impossible really to see how a good submission can't actually integrate both points. But it demands complete project records. And the type of records in a lot of instances, and they're company specific, of course, but it is an industry awash with lots and lots of record. It's the type of records, it's quality of records. A lot of the instances, it just doesn't take that much adjusting. The difference in windows can produce different results. The back analysis is costly and laborious, especially if it's retrospective. If we're dealing with a project, if we're in a dispute and we're seeking these elements, it is an enormous task in terms of revenue. And even for experts in terms of litigation, or during these type of disputes, are trying to prove delay. I would say to most parties not to forget that while people will often see the direct cost of employing such an expert or consultant, they also have the cost of the internal resources to collate all of this information, to provide all the information, because all of that has to be done. So when we look now at the time impact analysis, it's similar, it's a variant of the window technique, but this technique concentrates on a specific delay, but not on the time periods containing those delays. And this is one of the elements that I really very much enjoy when we see how these events actually take place, in terms of producing potentially a separate program for delay with every activity on that, rather than the traditional one red line on an ASTA power project, which is for 12 weeks or 14 weeks until there's little else. But what we're actually suggesting is a picture is generated each time there's a delaying event. we're now looking into all, and these are wonderful points because we can now get into causation. We can get into all of the different elements that actually builds up what a well-presented claim looks like, followed by each different event, each different interaction, and contemporaneous documents being appended to that program to actually verify all of those events. And it's an incredibly difficult state of affairs to actually contend against. And this really assists. And if you're very strong on a liability point, it becomes very, very much a powerful weapon. The network is then updated upon this delay period, and the effective delay is used to establish new completion date. It's detailed, it's more likely to be accurate, delays are real time, and the critical path is recognized throughout. The cons: it may not be practical for smaller projects, depending on the education within. It's highly laborious, it's costly, and time consuming. So, which is the correct technique? And on one hand, there's no straightforward answer as each principle, but ultimately it becomes a nature of what is the quality of evidence? What's the quality of information? To try and apply really weak information surrounding a certain set of circumstances, you might transcend into one of 1 to 3. And these are the reasons why there are so many. It's the quality of the evidence. The more likely it is that with those habits that are the site resource or the management of a particular project, are they aware to trigger events when something has changed against what the common intention was. If they're alive to that, then they can adjust and they can record and understand what to record and the level of that detail. In those instances, it becomes actually very much part and parcel of a daily activity. And it becomes not expensive law, really. It just becomes a function of what one would expect of their daily duty. Well, clearly as the amounts arise, the greater the input to prove. The techniques employed have been a source of contention. And remember as well, like Noda we mentioned, the courts in many instances, they will look for contemporaries, the real set of events, to present a case of all theoretical instances towards a court or an adjudication. It simply will never be of the strength to allow it against something that's contemporaneous, or more likely than not be the better version of events, and that must be the aim. So in this particular case of Balfour Beatty, the adjudicator's decision was challenged as the technique was not provided with commentary by the respondent. Again, when we talk about ask on contractors, which was a case in the Isle of Man surrounding some construction offshore, wholly theoretical calculations would be unlikely to succeed. So with that, that brings us to the end this evening, and thanks very much, and apologies I've overrun a little bit, but if I could take, there are a number of questions that are just coming up into the screen now. So I will actually just take from the point of view. So first question is, under JCT, how can the contractor claim for instructions for expenditure of provisional sums as a relevant event when they are shown in the program? Ultimately, to explain the point, and I think that's earlier on, that when you attach a provisional sum in itself, you would be putting forward that there is a provisional sum in itself. You're then looking to regard that to attach to a relevant event. So we're talking about notional points here that you may make it very, very clear, and I think that is a very good point of the question raised. You must make it extremely clear on that the time that could be allotted to that, either by a milestone, by dates or times allocated to that, are provisional, of course, and subject to establishment of what the real events are. So you will have to mobilize a relevant event on that, which is a variation, falls under the variation rules. But that is a very good question and comment. you must make it very explicit that before you find yourself locked in. But ultimately, we're looking at towards that it falls under variation rules, which constitute a relevant event. But it needs to be very, very explicit on that point, I would suggest. And certainly under JCT, when is the 12-week period triggered for the time for the EA to issue its EOT assessment? So, yeah, so essentially where this question actually relates to is invariably there is no sanction realistically under the JCT. JCT provides that there's 12 weeks in order for a CA or an EA to make their assessment of whatever delay there is after it's been properly submitted. But there are two distinct timelines, one up till practical completion, and certainly you've got 12 weeks after practical completion when the EA or CA should make their position known in respect of what they think of the points. Ultimately, there is no sanction if the CA or EA does not. So it's not like there's going to be a deemed acceptance if they haven't got back within that time. That is different from, say, the NEC 4, where you would expect that if there is a program submitted for acceptance, the project manager fails to respond or does not respond at all. What you would be suggesting if a dispute has crystallized, of course, on that point of the 12 weeks, and you would be asking for a third party, namely an adjudicator, to actually make a determination on such an instance as well. What would be the recommended delay analysis technique to use under JCT subcon, which has a duration schedule rather than a fully fledged program? Would it be correct to say NEC EC tries to enforce the time impact analysis through the project? Yeah, I think that ultimately there is no correct, and we're back to the point of which technique to actually use. So if we take the JCT subcon, which has a duration, it has a duration schedule. So usually this is not uncommon, especially when the contractor has appointed a subcontractor at that point in time, because they have a notice period to mobilize. They will generally give durations, which is quite fine. The dates can be inserted afterwards, they're reflective of the time. But again, specifically on that point, it could be any of those 6 methods, which some subcontractors might suit for the lesser amounts in that case. Would it be correct to say the NEC tries to enforce the time impact analysis throughout the project? There has certainly been, first of all, the NEC tries to go on a prospective basis. It leans away from a retrospective basis. It tries to look forward for perspective when we go to define costs and all of those instances as well. So it is looking for window, or it is looking for those techniques, and it generates at most points. It actually tries for Primavera. You'll find most projects being dealt with. There's nothing to stop it with ASTA. But it will go into a prospective. It will go into as detailed as possible when it goes to time impact on that instance as well.
Okay, so we also had a couple of questions from the chat panel as well.
Sorry, Julia, I didn't get that.
We had a couple of questions via the chat panel as well when you.
Oh, right, okay, yeah. How do delay analysis techniques work alongside those for calculating loss, i.e. using the but-for test and for establishing the dominant cause when reviewing claims for loss and expense, for example? Okay, so generally we haven't sort of brought in what would be, but these are what I would suggest when I hear a test like the but-for test and the dominant cause. We're now sort of looking at concurrency as well, and which delaying events take precedence on those. So the but-for test would be one that would always have been liked by contractors to suggest, but for your X, Y, and Z, these certain course of actions would have occurred. The dominant cause is the most dominant position in relation to delay event, which has the most, which provided causation, and it's causation issue in respect of that. Ultimately, that's a distinct argument. But those distinct arguments, whichever are successful, will immediately impact on what the result would be, because of course it's going to affect materially who is in delay, at that specific time, and how that actually then changes a critical path. Responsibility becomes really critically important on that as well. Okay, Julie, what we'll probably do is we'll probably leave there, but what I can do is we can answer a lot of these, the remaining, because I do know that there's quite a few in number. So what we'll try to do is actually list them all as a number of questions and take them all into separately.
Okay, I'll send you the details of the people that have asked, and we can make sure that this is updated for everyone that has asked a question that hasn't had it answered. Thank you, Henry, for your time. Thank you, everyone, for joining us. I hope to see you on another online webinar soon. Our July dates will be available by the end of this week, so keep an eye out for those and make sure you book onto those that are of interest. And the recording of tonight's seminar will be available as from tomorrow around about midday on our YouTube channel. The CPD certificates will be issued tomorrow as well. So thank you again. Thank you, Henry. And thank you to everyone who's attended. We hope to see you soon. Take care all. Stay safe.